Hi, and welcome to video 1 of the East Carolina Law Group's Season 2 of the Self-Help Series. I'm attorney Timothy Kohler, and today our first topic is going to be pro se representation. I'm going to represent myself in my own civil matter. So this video is going to cover whether the question we are going to answer is, should I represent myself? Stop what you're doing. Don't do it. Now, what I can't tell you is that you cannot represent yourself. You absolutely can represent yourself. Don't mistake that for saying that I'm saying that you should represent yourself. You should not represent yourself. Here are some issues that we tend to come up against when we're dealing with a pro se party. Many times, what happens is we'll get a consultation with somebody who comes into our office and they say, I'm a landlord, or I'm a tenant, or I loaned some money, or I had a contract with somebody, so on and so forth, and I sued them myself in small claims, and I won. Now, to the attorney, that doesn't sound nearly as good as to the person who's saying it. To the layperson, to the non-attorney, or normies, as we call you, saying I won in small claims court, it's about as good as saying, hey, I won my poker game last night at my friend's house. It doesn't mean a lot. Now, there's a reason for that. Number one, small claims court is a non-formal hearing setting, and any appeal that's taken from a small claims action is an appeal de novo. That's D-E-N-O-V-O, which is a Latin term. Effectively, for the layperson, it means mulligan. You get to do it all over again. But if you end up in a small claims case as a pro se, and then you appeal it, or somebody else appeals it, it goes to district court. You're no longer in kiddie court. You now actually have to file pleadings, which is not a one piece of paper that you get from the clerk's office. You have to issue a proper summons, but there's motions and things that need to be filed. Unless you are well versed in the North Carolina rules of civil procedure, particularly well-versed in rules 7 through 12, you are not going to be able to properly represent yourself in the district court. Once again, you're no longer in kiddie court. It's no longer an informal setting. Do you know what hearsay means? An out-of-court statement sought to prove the truth of the matter asserted? You probably don't know what any of that means. The important thing is, at that stage of the game, you definitely need an attorney. The reality is, you needed an attorney from the get-go. At the East Carolina Law Group, as the principal civil attorney here, I can tell you I never file a case in small claims court. The reason is, if you win, and there's a pretty good chance you're going to in small claims court, especially with an attorney, because you're not in front of a judge, and the rules generally don't apply, you're going to end up being appealed into district court. And if that happens, you're back to square one. So all the money that you've just spent on an attorney to win a judgment in small claims court is most likely going to be for nothing, because it's going to end up in district court anyway. In my previous experience, I found that many of the cases taken into small claims court with an attorney almost always get appealed to district. And any money you would spend on a flat fee for an attorney to go into a small claims hearing is just going to be a waste. If a client comes into my office and sits down and says, I want to sue someone in small claims court, the first thing I'm going to tell them is stop right there. If you hire us, you will not be going to small claims court. I don't care if you're suing for $100 or if you're suing for $10,000. You are not going to be going to small claims court because it's a waste of your time and money. The reason you need to hire an attorney is because you need an attorney that knows strategically where your case should be, how to move your case along, and how to properly manage your case. If everybody could represent themselves, there'd be no need for lawyers. It's important to remember that unless you have a working knowledge of not only the law, the substantive law, but also procedural law, you should not be representing yourself. And almost no pro se person has the ability to manage that in both respects on their own successfully. This is very difficult. The most common thing that we see come into this office is people who are trying to do their own divorces. Now, the one common thread that we hear very often is 20 years ago, I did my own divorce and we didn't have to go through all of this. Well, this office wasn't here 20 years ago and the law is very different than it was 20 years ago. The reality is, if you want something done and done correctly, you need to have proper counsel in order to do it. Having proper counsel means that your case is going to be filed properly, it's going to be managed properly, you're not going to have to worry about unnecessary delays for improper service, you're not going to have to worry about things like, did you file motion A, B, or C? Did you file such and such an affidavit? Well, I didn't know that. Ignorance is no excuse. And if you're going to represent yourself, a judge is not allowed to assist you, other attorneys cannot assist you, and the most important thing is, you are expected to perform to the level of an attorney. There is a reason why attorneys go to school for 7 to 10 years. It's not just because we like paying for school. I can tell you personally, I didn't like paying for school. However, it's a necessary evil when it comes to doing this job. The law is sacred, and the practice of law is a sacred thing. Working hard for your client is important, and doing things correctly the first time is also important. It's not to say that attorneys never make mistakes. Sometimes we do. But the difference is if we make a mistake, generally it's relatively minor and it can be rectified very quickly without any unnecessary delay or cost to the client. However, if a pro se party makes a mistake and a judge says, we can't hear your case now, I'm dismissing it, what do? There are certain questions that need to be asked. Do you know which ones they are? Am I going to tell you what they are? Absolutely not. I'm not giving you legal advice at this point. However, what I am telling you is that before you undertake representation of yourself, whether it be for an uncontested divorce, separation agreement, or any kind of civil lawsuit, you need to at least consult an attorney. One of the best places to find solid legal free advice is to go to avvo.com. That's avvo.com. However, one of the common threads that I tend to see when we go on the Q&A section to answer these free questions for people is attorneys saying, stop what you're doing, don't do it, you're in over your head. Most recently, we saw a question come through about a woman who was filing her own termination of parental rights against a father of her children. From a civil standpoint, this is the most serious thing that you can actually file against somebody. It is the only thing other than a capital death penalty case in the state of North Carolina that will get you an automatic appeal. It's very, very serious and absolutely not something that should be undertaken by yourself. There's many attorneys that won't undertake a private TPR. Doing it yourself as a pro se is just plain insane. And if you are the person who posted this question, I hope you're watching and taking this to heart. Trying to file a pro se TPR is just flat out insane. So please, before you go jumping into the clerk's office, finding a pro se package, and filing a civil lawsuit in small claims court against somebody, go consult an attorney. Whether it's us or anybody, get sound legal advice before taking the next step. Are attorneys expensive? Yes, they are. Is there a reason they're expensive? Yes, there is. So please, don't do it. Go find an attorney. You cannot competently represent yourself in most situations. Can you represent yourself? Yes. Should you? We would never recommend you do so. Hire an attorney, whether it's us or anybody. And as to the cost for legal services, look at our next video because we're going to explore some in-depth analysis on different legal costs and how much certain types of case cost. So if you have questions on how much it's going to cost to hire your own attorney, we can give you a pretty good idea on what we see as far as trends in our next video. So thank you for tuning into the East Carolina Law Group Self-Help Series. We hope that you found these videos informative and have been informational in helping you determine what your next course of action should be in your own particular situation. If you find yourself needing additional legal help, we're available and you can set up a consultation by calling our office at 252-453-2273. That's 252-453-2273. 2273, or you can look us up on our website at eastcarolinalaw.com, or you can find us on Facebook at the East Carolina Law Group, and we post regularly on there, sometimes almost daily. We put everything from new legal information to office closures and things of that nature, and we provide updates on things that are happening in North Carolina and in our local district. So once again, if you need to get in touch with us, it's 252-453-2273. The East Carolina Law Group, where your family is our priority.